I've been asked a question this week about a UK hotel booking. In short, the consumer booked the hotel room via the hotel's website. He looked through all of the different room types that they had and chose the one that he was going to book, primarily, he says, from the pictures that were shown. Now, this is an important point because the hotel website showed pictures or 3 variations of this particular room type. Each variation looked fairly similar in size, in style, just with very small differences between them. So based on that and based on the descriptions of the room as well, he decided that he would book that particular room. He clicked pay now, paid the deposit, then got an email confirming his booking and confirming the actual room type that he had booked. Now what happens next? He turns up to the hotel and the room, unsurprisingly, because I hear this all the time, looks nothing like the picture on the website. In fact, it looked strikingly similar to another room type that the hotel had on its website. So he made a complaint to the hotel. They haven't come back to him, or they hadn't come back to him at the time he contacted me initially. Therefore, he came to me and said, "What are my rights?" Now, before I go further, let me just say this. This is not a package holiday. A package holiday is where you book accommodation and the travel together, or at least 2 elements together. This is not that. Normally, package holidays are overseas holidays, but they can be UK-based holidays as well. But as I say, this is not one of those. So I'm not going to be talking about your rights when you've booked a package holiday. Save us to say, when you do book a package holiday, you get far more rights and it's far easier to deal with your complaint if something goes wrong. Let's come back to this issue. So here it's a UK-based holiday or UK-based hotel booking. Something's gone wrong. The applicable law is the Consumer Rights Act, the law I talk about nearly every week in relation to goods and services. Now here, the hotel room is effectively goods, and the Act, the Consumer Rights Act, says that not only does it apply to goods, but it also applies to the hire of goods. So here, our reader has effectively hired the room, therefore it falls within the Consumer Rights Act. Now, the important part of the Act here is the part that says goods or the hire of goods must be as described. Now, the description is not only what's written down on the website, it's also what's shown on the website, i.e. photographs. So the situation here is the photograph of the room that the reader saw and based his purchasing decision on, it was nothing like, as I've already said, the room he actually got. Therefore, there is a clear breach of the Consumer Rights Act. And in fact, the room type that he actually got was cheaper than the one that he was actually booking or the one that he had booked, therefore meaning he's entitled to a remedy. Now in law, this amounts to what we call, us lawyers call, a breach of contract, and that means there is a remedy under the Consumer Rights Act. Now because he went forward and he used the hotel, he stayed in that room for the duration of the booking, he's not going to be entitled to all of his money back, but he is going to be entitled to some of it because, let's face it, this room was not worth the same money as the room that he actually booked and paid for. Therefore, he's going to be entitled to the difference back. That's the difference between what the room he actually got cost and the room that he actually booked and paid for. And there will be a difference, and I understand it's about £200 here, so it's a lot of money. He's entitled to that money back. He's also potentially entitled to claim for his loss of enjoyment because, as he told me, this ruined his weekend. He thought he was going to get a much better room. The room he got was not what he bargained for, and therefore his family were upset. He's potentially got a claim with this. Traders often say, well, under the Consumer Rights Act, there are remedies set out, and beyond those remedies, you can't claim any further. Those traders, including hotels, car dealerships, retailers, and so forth, are wrong, because the Consumer Rights Act clearly says that it does not exclude the possibility of consumers claiming consequential losses. Those are losses such as what you suffered as a result of the original breach. Here, our reader was upset. Here, our reader's family had a loss of enjoyment. That's a consequential loss, so I think he's probably entitled to claim for that as well. Now, if this hotel had continued to ignore him, he would have had two choices. One, go off to the small claims court, make a claim. Secondly, because I know in this situation he paid by his credit card, he could go back to his card provider, initially because he's within 120 days, make a chargeback claim, basically saying there has been a breach of contract. I pause there for a moment because the words breach of contract, when you make a chargeback claim or a Section 75 claim, are imperative. Without those words, you don't have a claim. There must therefore be a breach of contract. Here there has been. There has been because the hotel room was not as described. So what he'd be saying to his card provider is, I'm not entitled to all my money back, but I'm entitled to the difference in the value of these two rooms. Therefore, can you claw that amount back from the hotel and put it back into my room? The answer to that question should be yes from the card provider. If it's not, then the reader would have the opportunity to go and make a claim from the Financial Ombudsman Service, who I think, on the facts of this case, would find in his favour. Although, I don't think it's going to be necessary. I think this is a very straightforward chargeback claim. Now, I should say, if he had left this and it was outside of 120 days, because he paid on his credit card, he would be able to make a Section 75 claim because this room was more than £100 and 1p, which is the requirement under the Act. And of course, it was less than £30,000, which is the ceiling for Section 75 claims. And again, there's a breach of contract. Therefore, there ought to be a successful Section 75 claim. Now, there's a good ending to this story because here, our reader does not need to do any of these steps. He doesn't need to go to court. He doesn't need to make a chargeback or Section 75 claim because after my intervention, the hotel has come back. It's put its hands up and said, yes, you were misled. We have now changed our website because the room pictures were not correct and we are going to give you, they've offered a free stay. He may or may not accept that. If he wants to, that's fine. If he doesn't want to accept it, he is entitled to have the difference back, as I said before.